Welcome everyone to this special webinar on immigration and how the changes can impact you, your family, and your business. So today we have a big agenda for you. We will be talking about how the April presidential order impacts U.S. immigration. We're going to talk about the current trends in employment-based immigration, options for survivors and domestic violence, the impact of public charge. And of course, at the end of the formal presentation, we're going to be taking questions from our panelists so they can answer your questions. So stay with us. And talking about panelists today, I want to welcome Marshall Cohen. Hi, Marshall. How are you?
Good. How are you, Gina?
Great. And Nisha Karnani. Nice to see you, Nisha.
Good to see you too, Gina.
Great. And Nicole, I'm sorry. Look at this. We're just starting and I'm already not being able to pronounce your beautiful, gorgeous last name, which is Waitnauer. Nicole, thank you so much for being here today.
Thank you, Gina.
Okay, so let's start with Marshall, since we have a big agenda and a lot of information for our viewers today. We're going to talk about how the April presidential order impacts U.S. immigration, Marshall.
Okay, thank you, Gina. So on April 22nd, President Trump issued an executive order limiting immigrant visa travel to the United States. Now, this only applies, first of all, to people outside the United States as of the date of the announcement, April 22nd. Mm-hmm. It paused immigration for 60 days, with the caveat that within 50 days of the order, the president could evaluate whether to extend or modify the order. Now, really, this order didn't do much because by the time he issued it, most of the consulates and embassies abroad had suspended in-person immigrant visa interviews. But we think it was just a political ploy to stop immigration. But that aside, one thing that you have to realize is that this order applied only to immigrant visas. Now, an immigrant visa is a permanent visa. It gives the visa holder the ability to ask for entry into the United States on a permanent visa, on a permanent basis. Some people refer to this as a green card visa, but it allows the person entering on the immigrant visa to remain in the United States indefinitely as a lawful permanent resident until and if immigration or the immigration judge takes away their permanent resident status. Now, there were several exceptions, but this did apply to both family-based and employment-based immigration. Let me backtrack just a little. When I say immigrant visa, there are two types of visas to enter the United States. There's an immigrant visa, which is for permanent residents, and there's a non-immigrant visa for temporary residents in the United States. Now, the temporary residence could be up to 6 or 7 years, depending on the type of visa, and it could be renewed, but it is not for permanent residents in the United States. So that's something that people need to understand and comprehend. This only applied to immigrant visas. Now, the order did not include anyone trying to enter the United States on advanced parole. Advanced parole is a document that is given by immigration while a green card application is pending. It allows the holder to, if they leave the United States while their green card application is being adjudicated, it allows them to re-enter the United States without a visa. Typically, it's issued on the same document as the employment authorization. So this order does not affect those people. Again, it does not affect people holding non-immigrant visas. Those include visitors, students, people coming to participate in sporting events, although there are no sporting events going on, TN visas, which were created pursuant to NAFTA, and other non-immigrant visas. Now, the president also recently came out with, on May 29th, with an order affecting Chinese students, but that was only for Chinese students attempting to enter the United States. It did not affect Chinese students already in the United States. There's also talk that the president will issue something regarding H-1Bs, which are visas typically given for jobs that require a university degree, but there's been nothing announced yet, although people say that there will be soon. So what this order did was it effectively paused issuance of immigrant visas for 60 days. There are several there are several categories of people that are exempted from this order, though. Lawful permanent residents, conditional and unconditional. Conditional permanent resident is someone that has been married for less than 2 years at the time their status was adjusted to permanent residence. So anyone with a green card can come and go into the United States. Also exempts certain healthcare professionals, their children, investor green card cases, spouses of U.S. citizens, children under 21 and some adoptees of U.S. citizens, members of the armed forces, their spouses and children, certain individuals needed for law enforcement purposes or the national interest. These are typically witnesses in criminal cases, and certain special immigrant visas, including spouses and children. So in all, this really was kind of a nonsensical order. It was a political move, but it did affect a large amount of people.
Great, thank you, Marshall. We have a question coming in right now, and it says, have there been any changes for non-immigrant visa holders?
There have not, except in the case of Chinese students. Now, I have the information about Chinese students. The proclamation on the 29th affected Chinese students who are in F or J status, or attempting to come in, who are in graduate level programs, or have been associated with the People's Republic of China entities involved with, quote, military civil fusion strategy. That only affects Chinese students outside the United States who are attempting to gain visas to come into the United States. Even though a Chinese student may receive documentation from USCIS telling them that they're subject to this exclusion, as long as they are in the United States, nothing will happen to them.
Okay, perfect. Well, for anybody who is tuning in right now, we're broadcasting this special webinar brought to you by Antonini Cohen Immigration Law Group. Here, this is Marshall speaking about the presidential order of April 22nd, and we're going to move on to Nisha. Nisha, we would like for you to talk to us about the current trends in employment-based immigration.
Thank you, Gina. So as Marshall mentioned, there were some employment-based green cards that were impacted by the executive order. The trends that we see going on outside of that order, the big hot topic at the moment is that premium processing, which is a system where immigration will take an additional fee of $1,440 to expedite processing of your case. Due to COVID-19, that process had been suspended. So immigration announced that they are starting to phase back in that process. So starting June 1st, if you need to expedite or premium process your I-140 petition, you can do so. Starting on June 8th, if you have a pending H-1B application, you can, that is not subject to the lottery, then you can do premium processing on your application. And then beginning on June 15th, if you have an application that is not pending, you may expedite your case as well. So the USCIS website has information on all these dates. for premium processing. And as for those of you who don't know, premium processing is very important for people who have non-immigrant visa applications pending or are extending those, because the regular processing time can take close to a year or even over a year. And so that results in problems with people getting their driver's licenses and having even work authorization. So this is very important news. And if you have a case pending, you definitely want to talk to your attorney about whether it's a good idea to do premium processing. The other big news in employment immigration is that there was some litigation, federal litigation, involving employment-based visa type called the H-1B visa. And most folks who are working in the US on temporary work visas are on H-1B visas. And one thing that had been happening is that folks who were renewing or filing new applications or changing employers, immigration was shortening the amount of time they had on validity if they only had a project that they were working on that was short. So some projects, especially in the IT and some engineering fields, the work is done by project. And so folks were filing for H-1B renewals and may have been here many years and getting a 6-month extension or a 1-year extension. And it was very stressful and expensive for employers too. So there was federal litigation was filed challenging this, and USCIS entered into a settlement agreement where they agreed to rescind a USCIS memo that was the basis of a lot of that, those shortened validity. The other thing that came out of the settlement is that the other challenges that some employers were having on H-1B approvals, where they were getting pushback to show if they worked at a client site, for example, that they were still an employee of the petitioner on their H-1B. And so a lot of those denials or requests for evidence were based on that memo that USCIS agreed to rescind. So the good news is that there has been, when folks are taking issues with immigration to court, we are seeing some success, especially when immigration is not following the proper procedures to change the rules and change the policies. So that's good news if you have an H-1B visa and you work, especially in the IT field, or if you work on a project basis, or if you work at an end client site, that's very good news for you guys. The other thing, Gina, that folks need to know is because of COVID-19, a lot of folks are unfortunately facing layoffs, furloughs, and specifically for H-1B visa holders, that can create a big problem, because if you're not working, you may not be maintaining your status. You may be out of status. And so there is a 60-day grace period. So if you have experienced a furlough or a layoff and you're an H-1B visa holder, you do have a 60-day grace period. It's not a very long period of time, but that's something that folks should know about and realize that to try to change status, depart the US, or find a new employer within that time. The other recent policy change that was positive is that USCIS has, in light of COVID-19, tried to alleviate some of the barriers to foreign medical staff and more foreign medical physicians, essentially, so that they can do telemedicine if they have gaps in their work, because maybe they have to stay away due to COVID-19 or exposure. Immigration passed a temporary memo to make things easier for those physicians. And there's probably going to be some more legislation that is helpful to foreign medical graduates in the works soon. Next slide, please.
Well, I got some questions here for you, Nisha. We're getting tons of questions from our chat. And regarding this, you're talking about a question that says, what are the processing times for employment-based visas right now? And also, if you expect changes on the H-1B visa process.
Gotcha. So the processing times for the employment-based visas depend largely on if it's a green card application or if it's a non-immigrant visa, as Marshall talked about before. The best way to look at the processing times is to check USCIS.gov, which is the immigration processing they have a chart where you click on a tab that says processing times. But realize that those processing times will be a little off because immigration had suspended its in-person services, and they will resume this week actually. But that created a change in the applications that immigration was working on. So for example, they stopped processing cases where there was an interview required, but they started focusing on other cases where there was not an interview required. And so we actually saw H-1B visas shortened down to 2 to 4 months or even less under this situation. And we've seen other cases like VAWA cases and U cases take longer. So the bottom line is just check the USCIS.gov, but then realize you may not see the impact of COVID-19 until about 90 days. And then if you check the USCIS processing time in about 90 days, I think you'll have a more accurate picture of how long your case is taking. But realize immigration slows down and speeds up all the time. So that's something that, while you can get an estimate, is not always completely accurate. And I think the other question you had, Gina, was whether there's a change to the H-1B visa process. There has not been just yet, but we are expecting that this administration will enact changes to the H-1B visa process. For example, in the memo that, or excuse me, the presidential order, they said that they were not changing anything with the non-immigrant visas. However, they did mention that around this period of time, they will be reviewing the H-1B and other non-immigrant visas to see if changes are needed. And there are certain types of visas where I expect we might see some changes, although we don't know exactly yet what they might be. But I think they probably will revolve over L1 visas and H1 visas. So that's something that you'd want to stay tuned for.
Perfect. For the people that are tuning in, we're talking, this is a special presentation brought to you by Antonini Cohen Immigration Law Group with Marshall, Nisha, and Nicole today. They're talking about the different changes in immigration that can affect you, your family, and your business. So we're going to move on to the next slide, which is very interesting as well. It's about the options that survivors of domestic violence have. And Nicole is going to talk to us about it. Hi, Nicole, welcome.
Thanks, Gina. Yes, one of the things we're unfortunately hearing is that law enforcement agencies and hospitals and doctors' offices are seeing an increase in domestic violence and family violence. This is across the nation as well as here in Georgia due to the pandemic. And so we want to make sure that everyone knows that there are immigration options available for survivors of domestic violence and other violent crimes. And so I'm not going to talk about all of the options that are available, but just some of the common ones and who are eligible for those types of immigration relief. So, you know, certain family members of U.S. citizens and green card holders, for example, spouses or children, may be eligible for relief under the Violence Against Women Act, commonly called VAWA. And they can file both affirmative or defensive applications. Affirmative just means that they are filing before United States Citizenship and Immigration Services, or USCIS. So that may mean that they came here without status, or that may mean that they had a student or some type of temporary status, and they want to be eligible to file for their green card. And so under VAWA, if you are a certain family member, if you have that relationship with a U.S. citizen, such as a spouse or a green card holder, and you have suffered what's called battery or extreme cruelty, you may be eligible for special protections under the Violence Against Women Act. And defensive application would just mean that you're filing this application before an immigration judge. So if you were in deportation or removal proceedings, and again, you've suffered domestic violence at the hands of a U.S. citizen or a green card holder, and you're either their spouse or their child, you may also qualify for this type of relief. So under both of these, if they are granted, if the special protection under VAWA is granted, then you may be eligible for your green card, which, as Marshall explained, would be a permanent type of status here in the United States, unless a judge takes it away. Another option would be a petition for immigrant status, which is commonly called the U visa. This is for survivors of violent crimes. Violent crimes means things like domestic violence, which here in Georgia, that could be battery, that could be assault, that could be cruelty to children in the 3rd degree. It could also be other crimes outside of domestic violence, such as armed robbery or aggravated assault, rape, sexual assault. So, you know, it's only eligible to victims of violent person-to-person crimes. And unlike VAWA, you don't have to prove any type of relationship with the perpetrator. So the perpetrator doesn't need to be a U.S. citizen or green card holder. It can be a stranger. But the focus for a U visa is more being able to show that you cooperated in the investigation or the prosecution of the crime. So this typically means that, you know, if, say, for example, you were a victim of an armed robbery, that when the police showed up, that you were helpful to the police, that you told them what time, you know, the robbery occurred, you told them what the perpetrator looked like, you described the scene, that sort of thing. There's no requirement necessarily that the perpetrator be arrested or that the perpetrator be convicted. The requirement is more that you are helpful to the police or the prosecutors. And if this U visa is approved, it's a temporary status that you get for 4 years. You are authorized to work with that status. And then after 3 years, you may be eligible for your green card. One of the one of the positives about the U visa is that it comes with a very generous waiver. So if you have maybe immigration violations in the past, it may be able to waive those, like a deportation order or multiple entries into the United States without status. On the other hand, one of the downsides to the U visa is that there are currently a lot of people who have applied, so there is a very long backlog. And so it's actually several years until immigration is even getting around to adjudicating or looking at these applications. And then the last type of relief I wanted to talk about today was an application for non-immigrant status, or T visa. The benefits to this application is very similar to the U visa. You get 4 years of temporary status, and after 3 years, you may also be eligible for a green card similar to the U. For this, you have to show that you've been a victim of human trafficking, and you have to you can show either that you've been a victim of labor trafficking or you've been a victim of sex trafficking. So labor trafficking may look like, you know, you were told about a job to work at a hotel, you know, you were promised that you were going to make $10 an hour, but then when you actually go to the job, they say that they're only going to pay you $2 an hour, way below the minimum wage, and that if you try and report them for not paying the minimum wage, they're going to call immigration on you. That may be an example of labor trafficking where you may be eligible for leave. And sex trafficking is just if you're required or you're forced to do a commercial sex act through force, fraud, or coercion. And for both the U visa and the T visa, one of the requirements is that you get the agency that was investigating the crime to certify that you were helpful. So this is something that your attorney or our office can help you handle. We can identify what the agency is that you need to request that they certify that you are helpful, and we can also help you with that actual request.
Perfect, and then they can also call 404-850-9394. It's Antonini Cohen Immigration Law Group. I have some questions for you, Nicole.
Sure.
One is asking if I have an order of deportation or removal, do I still qualify?
You may still qualify, yeah. So you would definitely want to talk to your immigration attorney about what this particular circumstances of your order are and to see what relief you're available to. But yes, you may still qualify for all three of the reliefs that I mentioned, depending on your particular circumstances.
And the other one is, if I apply for a U visa or T visa, is my information protected?
That's a really good question. And under VAWA, the U visa and the T visa, all of your information is actually protected by law. So this means that the USCIS officer that is reviewing your application, if somebody else calls, say the abusive spouse calls, immigration cannot give out any information about your case by law. And they take this very seriously because the actual individual officer can be fined if he's not complying with the law. So your information is protected.
Thank you so much, Nicole. We're gonna move on with Anisha, because I would like also to talk about something that we've been talking about for a long time, which is public charge. The impacts of the new public charge rule on your green card application. Nisha, you and I have talked about it in the past. Tell us more about it today, please.
Sure. So immigration always has had a rule when you're filing for a visa or a green card that you not be a person that will depend on the government, the US government, when you arrive. So that's always been in effect. However, immigration recently changed the rules effective in February this year to determine who would be considered a public charge. And they added, essentially what happened is they added a lot more burden on the applicant to show a lot more documentation and financial information to prove that you will not be reliant on government benefits. So starting February 24th, there's new forms if you're filing for your green card in the US. The US Department of State, which is if you're processing for your visa or green card outside the US, you're dealing with that agency. They also have implemented a public charge standard that is higher. And we're already seeing that folks are getting requests at their visa interviews at consulates for more information, especially folks who are older. So a lot of our filing for folks who are parents who maybe are retired, may have medical conditions. There's requests for things like proof of medical insurance, proof of assets, a lot more documentation. And this is really hard for a lot of families because if you're retired, it's very hard to show that you have significant savings, that you have, that you can get a job in the US. And so this has created more paperwork, more stress for folks. This does apply to temporary visa holders, the non-immigrants, and it also applies to the immigrants, which are the green card applicants. And the documents are also, in addition to the documents that you have to send, there's a very long form called the I94, which is a declaration of self-sufficiency. And that's required if you're filing for your green card in the US. And that is a very long form. It asks for a lot of information about any past public benefits that you may have applied for. It also asks for a lot of financial information, whereas in the past, we would just provide some basic information about employment and tax filings. So next slide, please. So one thing to know is that not every case is subject to this higher standard or this new public charge rule. So we've listed here, if you can see, the common cases that you do not have to worry about this rule. So that would be a lot of the humanitarian visas, the asylees, refugees, the cases that Nicole talked about, if you're filing for a U visa, T visa, or the green cards that are based on the U visa or T visa. The VAWA cases, which are under the Violence Against Women Act, special immigrant juvenile cases, TPS, which is temporary protected status. You don't have to worry about this rule if you are a permanent resident or if you're a US citizen. And we do get a lot of questions about whether this rule applies if you're filing for citizenship. So it does not. You don't have to worry about this. if you're applying for your citizenship. But if you are becoming a citizen and want to file for your family, then this is something that you would need to pay attention to. And next slide, please. So there are certain benefits that are going to be a problem for the public charge rule, and there are certain ones that are not. But one thing you should know is that the application asks you about all of them, whether they are going to consider them or not. You have to be really careful that you're truthful and you're checking with an attorney who knows what they're doing, because if you don't disclose certain things, that could be considered fraud or misrepresentation, and that could be something where the green card could be taken away or denied. And so it's very important that you speak with someone about your any past public benefit use. So as you can see on the screen here, these are applications where you could have a problem under the public charge rule. They are listed here: SNAP or food stamps, Medicaid with some exceptions. Now, when we say maybe a problem, it doesn't mean that you're going to get a denial, absolutely. What it means is immigration is going to look at the circumstances as a whole in your case. And so, for example, if the benefit use was a long time ago, or if there have been significant changes, there may be ways that you can overcome this public benefit use. However, again, you want to talk to an attorney about this and make sure that you have the strong application. Next slide, please. So these are some benefits that we get a lot of questions about that do not fall under the public charge rule. So while you might have to disclose them on the application, you should not be penalized for these. Now, that being said, if you have used these benefits and you're my client, I would want to talk to you about making sure that your financial sufficiency package is very strong, so that this is not going to be considered in the totality of the circumstances. And also, some of these benefits that are listed here, as you can see, some are just short-term benefits that you need for example, due to COVID-19, some folks might be using these benefits. So if they're temporary and they're short-lived, I would want to make sure I explain that, even though they're not a negative. So as you can see here, benefits received by the immigrant's family members should not be counted against family. They're all listed here. I won't read them all out to you, but the common ones we get questions on are health insurance under the Affordable Health Care Act, Medicaid received by children under 21 or during pregnancy or within 60 days of pregnancy, and individuals getting benefits under the Disability Education Act. So all of these are listed here. And if you have used these, remember again, you have to disclose it and talk to the attorney about how to make your financial package very strong. Next slide, please.
Thank
Okay,
you, Misha. I got some questions for you, and we're going to talk about this is in regards to public charge. The first one, it says, are there any benefits for immigrants who can who has a tourist visa who got stuck here during the pandemic?
So most public benefits are not available to someone who's here as a tourist. In fact, many public benefits are not available unless you're a citizen or maybe lawful permanent resident. And the public benefits vary. There's some federal benefits, but there are a lot of them that are really state specific. So usually a tourist is not going to be eligible for those benefits. However, things like emergency medical assistance may be available, although usually when you come as a tourist, you may have temporary insurance. So that's something that if you are here, you should extend, because it's very, very limited, unfortunately.
Okay, and the other one that I have for you says that the person wants to know how they can get prepared. It says, how do I prepare the public charge packet if I am a stay-at-home parent with no income?
Yes, so a lot of folks are not working or not formally working. And so if you're a stay-at-home parent, what we are doing is preparing a resume, actually. We're having our clients prepare a resume and help them list the skills that they have, because what you're showing is not that you're employed necessarily, but that you that you would be able to contribute financially if you needed to your household. So resumes are one example. Any prior skills that you have, any assets that you have in your family, explaining how what you do in the home enables other folks in the house to earn a living. A lot of folks have skills that they don't think of a lot of times. So there are also a lot of agencies that can help with skills development, resume development. But I think essentially showing the picture of how the family unit works and the income works and the contribution that person has. The rules do account for someone who does stay at home and is a caregiver. So that should be taken into consideration, but we're still showing that the person, if they were not a caregiver, would be a valuable contributing member in their family if they needed to. It becomes difficult also with folks who are older. So I think that's where it becomes important to show the family units, financial health and insurance. And that's also something that's very important. And one thing I forgot to mention earlier that we're getting a lot of questions about, Gina, is that folks are asking about unemployment benefits, especially because during COVID-19, a lot of folks are getting reduced hours or layoffs or furloughs. So employment benefits vary state by state. So some states, including Georgia, do allow folks who are lawfully here to apply for benefits, unemployment benefits, and that would not hurt your green card case. You would, again, want to connect the job loss and the situation to COVID. I think that would be helpful, but that should not impact your immigration case. Again, it's different state by state, and you have to look at what the requirements are. So if you are on DACA, for example, you could show your work permit to when you apply for unemployment benefits. If you do not have lawful status, though, then you would not be able to apply for unemployment, unfortunately.
Thank you so much, Nisha. Well, for everybody that's tuned in, especially also on Facebook as well, we are talking about the changes in immigration that can affect you, your family, and your business with Nicole, Nisha, and Marshall today. Thank you so much for being here with us. Marshall, I want you to talk to us about or give us an update on the closings, reopenings, and response times of the USCIS and Immigration Court. We know that that has been changing a lot due to the COVID-19.
And thanks, Gina. So immigration stopped in-person service in mid-March, and they kept posting on the website that they're going to reopen on this date and kept extending it. As of right now, they are saying that they're scheduled to reopen in-person services to the public on or after June 4th. We don't have any information that I'm aware of about the Atlanta office, so I assume that Atlanta is opening up. We just got 2 notices for oath ceremonies from the Atlanta office, so I'm assuming that the Atlanta office is opening up. On their website, USCIS is stating that they have some guidelines for in-person service. They're saying that a visitor may not enter a USCIS facility if they have any symptoms of COVID-19, including cough, fever, or difficulty breathing, if they've been in close contact with anyone known or suspected to have COVID-19 in the last 14 days, or if they've been individually directed to self-quarantine or self-isolate by a healthcare provider or public official within the last 14 days. Visitors may not enter the facility more than 15 minutes prior to their appointment, 30 minutes for naturalization ceremonies. Hand sanitizers will be provided for visitors at entry points, and members of the public must wear facial coverings that cover both the mouth and nose when entering facilities. They're saying that if they do not have one, USCIS may reschedule their appointment. I know that in our office, for our clients, we're ordering a lot of face masks. So if you're a client of ours and we're accompanying you to immigration for an interview, you will need to bring a face covering, but if you don't have one, we will be able to supply you with a mask. They're also saying that individuals may have to answer health screening questions before entering the facility. I can't imagine how well that's going to go. And that applicants and visitors are encouraged to bring their own black or blue pens. So that's what's happening with in-person interviews. Now, immigration canceled a lot of interviews, a lot of naturalization ceremonies, and appointments at application support centers these past few months, and they will be rescheduling them. If a person had an appointment scheduled, they should have received a letter from immigration stating that the appointment was canceled and it will be rescheduled, and it appears that they're starting to reschedule these canceled appointments. On their website, they're saying they will automatically reschedule any necessary application support center appointments. Application support center is where you get your biometrics taken for asylum applications, naturalization applications, and adjustment of status applications or green card applications. They say also that they cannot automatically reschedule appointments for Canadian and United Kingdom visa applicants. I don't know why. They don't say why. For asylum applicants, immigration is saying that they will automatically reschedule asylum interviews that were canceled during the temporary closure. When they do reschedule the interviews, asylum applicants will receive a new interview notice with a new time, date, and location for the interview and information about safety precautions. Also, they say that in accordance with social distancing guidelines and due to the length of asylum interviews, asylum offices expect to conduct video facilitated asylum interviews where the applicants sit in one room and the interviewing officer sits in another room. So it looks like you may be next door to your asylum officer and have to sit there and conduct the interview by video, which normally takes well over an hour, which promises to be really awkward and potentially disadvantage the asylum applicant. So this is all on the immigration website. There's a special banner for what they're doing during COVID-19, and this is all listed there. Naturalization oath ceremonies, they're going to send notices to applicants to reschedule them. The ceremonies may be shorter to limit exposure to those in attendance. CIS will not play videos during naturalization ceremonies, but will give attendees a flyer with information and links directing them to videos on the USCIS website. Under the shortened format, all legally required portions of the ceremony will take place, but attendance is limited to the candidates who are scheduled to be naturalized, a parent or trusted adult if the candidate is a minor, and individuals providing disability assistance to a candidate. Now, something really important, if you received a request for evidence or a notice of intent to deny, a notice of intent to revoke, a notice of intent to rescind, a notice of intent to terminate, or and you filed a request for a hearing on a decision in naturalization proceedings, if the notice was sent between March 1st and July 1st, you will be able to add 60 days, 60 calendar days to the decision, to the deadline. So let's say you received a request for evidence on an application to adjust status, and the date on the notice is, let's say, June 1st, and immigration gave you 30 days. That means that you can add 60 days to the July 1st deadline, okay? Also, USCIS will consider a notice of appeal or a motion for reconsideration or reopening, or and a request for hearing on a decision in naturalization proceedings if they are filed within 60 days from the issuance of a decision by USCIS. The normal deadline is 30 days, but they're giving an additional 30 days. So 60 days for those notices. For biometric appointments, USCIS states that they will automatically reschedule any necessary biometric appointments that were canceled. They're sending these out by mail, and they're stating that if you do not receive an appointment notice by mail within 90 days of the reopening, which for all intents and purposes is June 4th. So if you don't receive a new appointment by September 4th, they're directing us to call their 1-800 number. And then for asylum appointments, they're stating that they'll also be rescheduled, and that's about it for USCIS. For court, they are stating that the courts will be reopened on or after June 12th, and I'm just looking at their website. Right now, the two courts in Atlanta, the Ted Turner Drive Court is open for filings and detained hearings only. The West Peachtree Street Court is open just for filings. In any event, if you are in removal proceedings, please get a pen and paper. You should be calling the number I'm about to give you every 1 or 2 weeks, because the last thing in the world you want if you are in removal proceedings is to miss your appointment, whether it be your fault or the fault of the court. If you miss your appointment, it is a harrowing experience to get it reopened and rescheduled, and it is not a sure thing. So you should be calling this number and following the prompts and putting in your alien number. The number, this is an automated Executive Office for Immigration Review phone number, 1-800-898-7180. That's 1-800-898-7180. Again, if you had a hearing and it was canceled, you should be calling this number every couple of weeks to make sure that you know when your hearing is. And that about wraps it up for the court and USCIS during this time.
Thank you so much, Marshall. That was very important information and very interesting as well. I mean, I did get some of the questions, but basically you touch on everything that we needed to know about the schedule, if it applies to the Atlanta USCIS office, and also about the immigration court. So anything else that you want to add about that?
Just that all this information is on the USCIS website, which is www.uscis.gov. That's all the information for what we commonly call immigration. And then the immigration court is, the website is justice.gov/EOIR. That's justice.gov/EOIR.
Thank you, Marshall. And if you have any more questions or you want to talk to any of our attorneys at the office, you can call 404-850-9394. Well, this is the end of our formal presentation. Thank you so much, Nicole, Nisha, and Marshall. We're not done yet. This is the end of our formal presentation, but we got another 10 minutes of questions and answers, and I got a lot of questions for you. Are you guys ready?
Yes.
Perfect. Okay, so I have one that says, I have a sister who came with tourist visa on March 6th and the airport in Guatemala is closed and she can't go back. What happens if she still can't go back after the tourist visa expires in 6 months? Can she apply for an extension?
Gina, I can answer that one for you. So what you would want to do is apply for extension, as you mentioned. you can go to the same website Marshall mentioned, USCIS.gov, and you'd be filing an extension of her visitor status. It's very important that you file it before her I-94 expires. The I-94 is the time she's allowed to stay for this trip, and that's electronic, and they should have also written that in her passport. So as long as you file the application and it reaches immigration before that date, she should be in good shape. Some folks use an attorney for this. We've been doing a lot of these lately due to COVID-19, but some folks do it on their own, and you're going to look at the form I-539. And make sure you, if you do not use an attorney, you read the instructions very, very carefully. Immigration has said they're going to take into account COVID-19 situations. If I were you, I would try to submit evidence of the closures and the shelter in place and the flight restrictions of the home country as well. Like I said, we've done this for several folks, and even if she has passed her time that she was allowed to stay, immigration has mentioned that they would allow some applications under something called nunc-pro-tunc, which is essentially backdating the date of filing. So if you have a situation where you have noticed that you've overstayed the I-94 time, that you definitely need to call an attorney and have them help you with that, because there's some consequences if immigration doesn't adjudicate that application on time. But there are a lot of folks in this situation, so file your extensions, call us or another competent attorney so they can help you. The most important thing is timing. Just watch when that I-94 expires.
Thank you so much, Nisha. We got another question here. It says, I'm a US citizen and my husband applied for a green card. Can you explain the premium process? Before COVID, he had an appointment to get his biometrics done, and we have not heard back from them on that.
I'll answer that one too, because they mentioned the premium process, and that's actually unfortunately only available for work-based or employment-based green cards and visas. So we wish we could expedite the family cases, but unfortunately we won't be able to do that.
Okay. Thank you. Here's another one. It says, I got married in 2016 and later I got divorced 2 years. I got a divorce 2 years later. I received my green card in 2018. My 2-year green card expired in March. I sent the papers to do a removing of conditions and I received the receipt and did my biometrics.
Marshall, do you want to take that one?
Yeah, the question is, how long does it take to have my interview appointment?
Yes.
We have no idea. It used to be that you could expect, well, for 751s, there was a huge backlog. In essence, we just don't know what immigration is going to do going forward, because for approximately almost 3 months, they stopped interviewing. So they can only do so many interviews a day. So everything is going to be delayed. Now, they said that during the pandemic and while they were shut to the public, they were still adjudicating applications. But under previous administrations, our association, the American Immigration Lawyers Association, had a very strong liaison relationship with USCIS. We met periodically, we asked them questions, they told us what the backlogs were, how they were processing, what they were doing to deal with the backlogs. That all ended under the Trump administration. We have very little access to immigration. We're not meeting with them because they refuse to meet with us. So we really, they're kind of a black box. We just don't know what's going on in there. The only information we really have is from the website where they give processing estimates. And anybody can access that. You go to the USCIS website, which is USCIS.gov, and there's a link to processing times, and you can enter either your receipt number, and it will tell you what's going on with your case, or there's another link for processing times, which give general processing times for each type of application according to where it's been filed. So that was a long answer to say we have no idea.
Thank
will
you so
just-
much, Marshall. Another one here, it says, is state unemployment included in public charge?
No. So unemployment benefits, if you're eligible for them, they will not be used against you in the public charge process, but remember, you might have to disclose that you needed those. And I'll just add to something Marshall was saying about processing times. If you have an attorney who filed your case, you can ask them what they're seeing on the ground. So sometimes I tell clients, I got a case approved today that I filed on this date. Now that doesn't mean that's how long your case is going to take. And typically it's a little bit different than the processing times, but it gives you some general idea. And one thing you have to remember is immigration works on one type of case and then we get a bunch of decisions and then they focus on another. And so it is really hard to say, I did get 751 approved that did not need an interview, and that took around, I think that case was filed 13 months ago. But that was a case that did not require an interview. So I would imagine the cases that do get scheduled for an interview would take longer. If you file, I think the person who had asked the question said if you have, they had filed to remove the condition based on the divorce, so you need a waiver. Those cases are very often interviewed, so that could take longer.
Okay.
And Gina, I just want to add one thing. There's absolutely no source of information for how long it is going to take to reschedule the interviews that were canceled. We really don't know. We hope that immigration is following a first in, first out policy, that they're going to give precedence to the people that had applications that were canceled, but we can't definitively say yes or no because we just don't know.
Okay, great. Thank you, Marshall. Another question. My wife did her biometrics for her I-751. Could that be used for the N400 that I did for her recently?
No. They don't reuse biometrics on different types of applications. That's been their past policy. It may change. It would make sense to do that because it's done electronically, but we can't trust immigration to do things efficiently. Logically, yeah.
Perfect. Well, that is all the time we got today. Thank you so much for being here.
Thank you.
Thank you, Gina.
Anything else you want to add before I say your phone number? And well, actually, why don't you give us your address, the information, the web address, the phone number? Oh, there you go. Somebody can tell us.
Go for it, Nick.
Sure. So yeah, our address is 2751 Buford Highway Northeast, Suite 800, Atlanta, Georgia 30324. And you can email us at info@antoniniandcohen.com, or you can call us at 404-850-9394.
Thank you so much again. Again, the phone number 404-850-9394. A lot of people have been asking for this number, so please write it down. And thank you everybody for being here today. I hope you enjoyed it and got a lot of information. It's great information regarding, obviously, immigration from our my great friends from Antonini Cohen Law Group. Thank you so much. Have a great day.
Gina, I'd just like to add one thing before we leave.
Go ahead.
Our office has not been accepting in-person appointments. We are starting that back, we will send out a announcement to all our clients and everyone on our email list. But we will ask people to come in to schedule in advance, no walk-ins, and to come in with a face covering. But we will have face coverings if the person doesn't have it. And we are asking people to limit the number of people they bring to the office. But the main point is that we are opening back up to in-person appointments. Okay?
That is wonderful news. I hope I can see you in person very soon. Thank you so much. I really appreciate it, and have a great day.
Thank you.
Thanks, Gina.
Thank you. Bye.
Thank you, everyone.